Hello everyone, welcome to the channel Scientellectual. In this video, we are covering Chapter 6. The heading of Chapter 6 is Anticipation. And the sections that will be covered under Chapter 6 of Indian Patents Act 1970 are Section 29 to 34. Section 29, Anticipation by Previous Publication. Subsection 1 says an invention is not anticipated if it was published in a specification filed as patent application in India before 1st January 1912. That is, if any subject matter of the patent application is already published in any another Indian patent application before 1st January 1912, then the present subject matter will not be anticipated. Subsection 2, it says that an invention is not anticipated if the invention was published before the priority date of the claim of the specification, and in that case patentee or applicant for the patent proves that the matter was obtained from him and published without his consent, and where patentee or applicant learned of the publication before the date of the application for the patent, or in case of convention application before the filing of application in convention country, they have made the application as soon as reasonably practicable, then the subject matter will not be considered as anticipated. Provided the invention was before the priority date of the claim, it was not commercially worked in India other than reasonable trial, either by patentee or applicant of the patent, or any person from whom he derives title, or any other person with the consent of patentee or applicant or person from whom he derives title. Section 29, subsection 3. An invention is not anticipated if any other application for a patent in respect of the same invention made in contravention of the rights of that person, or by reason only that after the date of filing of that other application, the invention was used or published without the consent of the person by the applicant in respect of that other application, or by any other person in consequence of any disclosure of any invention by that applicant. Section 30. Anticipation by previous communication to government. If the communication of any invention is done to the government or to any person authorized by the government for the purpose of investigation of the invention or its merits, then the subject matter of the present invention will not be considered as anticipated. Section 31. Anticipation by public display, etc. An invention will not be anticipated if number 1. The display of the invention with the consent of true and first inventor or person deriving title from him is done at any industrial or other exhibition conducted by central government, notifying in the official gazette, or use with his consent for the purpose of such exhibition, then the subject matter or the invention is not anticipated. Similarly, publication of any description of the invention in consequence of such display or use of the invention at that kind of exhibition that is conducted by central government, then that publication will not anticipate the present invention. Similarly, use of invention after it has been displayed or used at such exhibition, and during exhibition if someone else uses that invention without the consent of true and first inventor, then the subject matter will not be anticipated. And similarly, the description of the invention in a paper, if it is read by the true and first inventor before a learned society, that is in any conference, or published with his consent, in such society. In all these cases, if the application for the patent is made by the true and first inventor or person deriving title from him, not later than 12 months after the opening of such exhibition or reading or publication of the paper. That is, within 12 months of exhibition, display, or publication in any government conducted industrial exhibition or in any conference, then within 12 months of that exhibition or conference, if true and first inventor files the patent application, then the subject matter will not be anticipated. Section 32. Anticipation by public working. The invention is not anticipated if at any time within 1 year before the priority date of the claim of the specification, the invention was publicly worked in India either by the patentee or applicant for the patent or any person from whom he derives title, or by any other person with the consent of the patentee or applicant for the patent or any other person from whom he derives title. But the conditions are if the working is done for the purpose of reasonable trial only, or it was reasonably necessary, or having regard to the nature of the invention, the working of that purpose should be effected in public. Section 33. Anticipation by use and publication after provisional specification. Subsection 1 says, when the complete specification is filed after filing a provisional specification, or complete specification is filed along with an application which is treated by virtue of under direction of section 9(3), the controller shall not refuse or revoke or invalidate the grant of patent by reason only that the matter described in provisional was used or published in India and elsewhere any time after the date of filing of the specification. Subsection 2 says, in case of convention application, the controller shall not refuse or revoke or invalidate the grant of patent by reason only that the matter disclosed in application for protection in convention country was used or published in India or elsewhere any time after the date of application for protection. That is, if the subject matter of the present invention is used or published after the date of filing of the specification, then only for that reason the controller shall not refuse or revoke or invalidate the grant of the present application. Section 34. No anticipation if circumstances are only described in section 29, 30, 31 and 32. The controller shall not refuse or revoke or invalidate to grant a patent by reason only of any circumstances which do not constitute an anticipation of invention claimed in the specification as discussed under section 29 to 32. That is, whatever has been discussed under section 29 to 32. If the patent application is not anticipated, then controller shall not refuse or revoke or invalidate the grant of that patent application. Thank you everyone for watching the video. Hope you like it. Please give a like and please share and subscribe the channel Scientellectual. We are covering all the sections, rules, forms and fees within Indian Patents Act 1970. And Scientellectual believes that it will be very helpful during the preparation of Indian Patent Agent exam. Thank you all.